point in time. We will also do question and answers again at the end of the session and open it up. All right, so for that, let's get started. So first, I am Michelle Boyce, Vice President, Rosenzweig Financial Services, and I will be your moderator this evening. So it's my pleasure to introduce our two speakers. The first one, most of you probably know, Mr. Mickey Rosenzweig, who's President and CEO of Rosenzweig Financial Services. Mickey founded the firm back in 1979 and has been helping clients with their insurance and financial needs ever since then. Throughout his career, he's gained vast knowledge in many different aspects of the industry. But why Mickey is on tonight and helping speak on the estate planning topic is because throughout his career, he's been on many estate planning councils. Currently, he sits on the Boca Raton Estate Planning Council and has even held the title of president at the New York City Estate Planning Council. So, Mickey, thank you for joining us this evening. And then we have Mr. Joshua Goldclatz, who practices, he's an estate planning attorney at Gunster's Law in Boca Raton here in Florida. He is an accredited estate planning attorney who is certified in wills, trusts, and estates, the typical the estate planning, but really concentrates his practice in the areas of tax, estate planning, asset protection for high net worth individuals, and looks at estate planning as a more holistic of how can we implement different strategies in our most tax efficient manner for generation one and then also generation two. So Joshua, thank you for joining us tonight. And I know with your firm, you really are in the estate planning side, but Gunster does other services as well. So if you want to take like 30 seconds and just tell a little bit about your firm so everyone on the call can get a better understanding.
Great, absolutely. Thanks, Michelle. Thanks for having me. So as Michelle mentioned, the law firm that I work for is Gunster, formerly known as Gunster, Yoakley and Stewart, but we're now just known as Gunster. We're a Florida-only firm. I think it might be Florida's oldest law firm. This is our 100th year anniversary, actually, and so we've grown from a firm 100 years ago that started as an estate planning firm on Palm Beach Island, servicing wealthy clients, into a full-service business law firm with around almost 300 attorneys throughout the state of Florida, spread throughout our 12 offices throughout Florida. And so the firm is, as I mentioned, we like to brand ourselves as Florida's business law firm, where we can handle, we have clients that are on the personal individual side and also the corporate side. So we handle corporate, real estate, any transactional work, business litigation, employment law, immigration, anything that touches individuals or businesses. And so as Michelle mentioned, I'm part of our estate planning private wealth services group, one of our biggest practice groups, which there's approximately 50 to 60 of us in the private wealth services group, but we can help all Floridians and Florida residents in any real legal issues that they may come across, business or personal.
Perfect. Thank you, Josh. So why did we choose estate planning as this month's topic, right? So we're in March. It's our third month of hosting our webinar series. And we chose estate planning this month because oftentimes we see individuals and clients who do a great job through what I like to call the accumulation phase of their life. They're good savers. They've been great at creating wealth. They get to retirement. They have a nice retirement plan, but they haven't always done the planning to protect their wealth and then done the proper planning for how does that wealth get transferred to the next generation in the most tax efficient manner. So that's really why we wanted to pick estate planning as this month's topic. So I always like to set the stage on this, So Josh, let's talk about in the most simplest form, how we would describe estate planning and what that means from the legal front and what type of documents would accompany a traditional estate plan.
Yeah, thanks, Michelle. Absolutely. And so typically when we start with clients, we start with the core documents, the basic set of documents that really anyone should have when they're looking to start an estate plan. Obviously, wills come to mind for most clients and most people, and generally people know what wills are. They've seen it in the movies. They've seen, oh, someone passes away, we're gonna have a big will signing and gather around the table and read dad's will or mom's will. Doesn't necessarily happen that way. We've had clients that call and say, when's the will sign or will reading, but it doesn't necessarily happen that way. But But really the core set of documents, and particularly in Florida, there's 5 documents. There's a will, a revocable trust, and I'll get into that and why in Florida revocable trusts are important and how that works together with a will. Those are 2 documents that really deal with disposition of assets upon death. So when an individual passes away, what happens to those assets? How do they get distributed to heirs or beneficiaries? And then the other documents that deal with incapacity during lifetime. So durable power of attorney, healthcare surrogate designation, and living will. And so that's the real core set of documents. And again, back to the wills and revocable trusts. And revocable trusts are very common in Florida and common in other states like New York as well. And the reason being is that when an individual passes away, if they only have a will, the will then gets submitted to the court, and then the court reviews the will, make sure it's executed properly, make sure it was done in the right way, and then we'll issue an order appointing the personal representative. That's what we call it in Florida. Some states like New York call it an executor. And then you're now in what's called the probate process. So clients come to us, and we've had clients come and say, I don't know much, but I know I want to avoid probate. They don't know what probate is, but they know they don't want to go through it and they want to avoid it. And so probate is really that process that's overseen by the court once a will gets submitted. And so the probate process, given that it's overseen by the court, can be a little more expensive, a little more timely. It takes a while to get the estate open. And again, depending on the state that you're in, and Florida and certain counties are not the swiftest. My experience from New York as well is that not the swiftest of courts. And so I would say 99.9% of our clients use revocable trusts to just for the main disposition of their assets, the main dispositive document. And the reason being is that with a revocable trust, if a client funds that trust during their lifetime, then upon incapacity or death, the successor trustee just takes over. You don't have to go to court. You don't have to get a court order. You don't then have to go through the steps and the slow process and expense of going through court. The successor trustee can then just take over and do what they need to do to distribute the assets in accordance with the individual's wishes. Now, a will and a revocable trust work together. When you have both, when a client has both, the will is commonly referred to as a pour-over will, meaning that essentially the will says that any remaining assets that are not already in my trust, that I did not put in my trust during my lifetime, pour into the trust at death, so that they all get to the trust ultimately, and they get to the same place and the wishes are carried out. But the will is sort of a safety net just to make sure there's any assets that were not transferred during life into the trust at death. And so wills are also important for clients that have minor children, where they can name a guardian of any minor child in the event something were to happen to them and their spouse or the other parent. So wills are still important and serve certain functions, but really the revocable trust ultimately would be the main dispositive document to distribute the assets upon an individual's death. And so the will and the revocable trust work together. And that's why in Florida and New York and some other states where probate and the courts are slow and backed up and crowded, that revocable trust really become an important piece to an estate plan. And there's some more flexibility with trust that we can talk about, but the will and revocable trust are the 2 core documents. And then along with the documents during life for incapacity is the durable power of attorney. So in the event an individual becomes incapacitated during their lifetime, the durable power of attorney makes all those decisions other than healthcare decisions. So where the individual lives, if they need to move to a nursing home, assisted living facility, how bills are paid, how tax returns are filed. That's what the agent under the durable power of attorney does. So appointing someone to make those decisions and help out in the event of incapacity. And then there's the healthcare surrogate designation and living will, and those deal with who makes decisions in the event that you can't make your own healthcare decisions. That's the healthcare surrogate. And then the living will is what some refer to as the pull the plug document, indicating what your wishes are if you're in a particular stage and don't want to be kept alive merely by the use of machines. And so those core documents, let's call it 5 documents: will, revocable trust, power of attorney, healthcare surrogate, and living will are really the core of what we start with when talking to our clients.
So Josh, 2 follow-up questions from that, because throughout my career, I've had people ask, So the first around the word trust, oftentimes when people hear trust, they think, okay, I'm going to lose control.
Right.
So maybe just give a little bit of an example of how a revocable trust works and that people really don't lose control of that.
Yeah, absolutely. That's the word right there, revocable. Is, obviously, as you mentioned, clients get hesitant when they hear the word trust. They think their assets are being tied up. They don't really understand it. But a revocable trust during the client's lifetime, them and their revocable trust are one and the same. They can, just like their will, they can amend it at any time. They could revoke it. They could come back to me in a month, a year, or 10 years and make any changes they want, so long as they have the capacity to do so. So they can, the revocable trust uses the client's, the grantor, the person that creates a trust, uses their social security number. So you don't need a separate social security number. The client is the trustee from the outset, and the trust provides provisions that essentially the grantor can do whatever they want during their lifetime. So really the client does not notice any difference between assets in their own revocable trust or in their own name during their lifetime. The only difference is the bank account says Josh Goldglantz as trustee of the Josh Goldglantz Trust, as opposed to just my name. So during lifetime, clients can be comforted in knowing that the word revocable is right there. Sometimes it's referred to as a living trust or revocable living trust for individuals that have heard that term before. But yeah, certainly that this is different from an irrevocable trust, which is more for tax planning. We'll get into it a little bit later, more for estate tax planning. And that's the next step or the next level of planning here. The building blocks with the will and the revocable trust provide as much flexibility to clients as they would have otherwise.
Perfect. Thank you for explaining that. So really that's the foundation, right? That core package is their foundation to any basic estate plan.
That's right.
Okay.
Absolutely.
So now that you explained a little bit about, the building blocks, as you called it, of an estate plan, throughout your career, I'm sure you've seen the good, the bad, and the ugly, right? So what would you say is one of the most common mistakes that you see that individuals have done when they've tried to do this type of planning?
Yeah, no, absolutely. That's a great question. We see this a lot. And so where we get asked that a lot, clients come in and they ask that question and they want to know what the mistakes that, we see from other clients. And, we take a holistic approach to estate planning. So certainly those are the core documents, and we're concerned with our clients' wishes and desires and how they want their plan to be drafted and how they want their assets to be distributed upon death. But we also, we want to take this holistic approach to make sure we're taking the 30,000-foot view as in addition to the narrow scope view. And the 30,000-foot view also takes into account the beneficiaries and how they receive the assets. And, are those assets protected for them? Do the clients have a charitable intent? Are there tax planning involved? So there are many components to estate planning. One of the biggest mistakes that we've seen is when clients come to us, there's been a shift in the way estate plans have been drafted over the last number of years. So historically, estate plans would have been drafted where individual passes away, and yeah, their assets may stay in trust for a beneficiary, but the trust would have staged distributions for those beneficiaries, meaning that it would say, okay, my beneficiary grandchild receives a third of the assets at age 25, maybe half at age 30, and then the balance at age 35. And at age 35, the assets go outright to that beneficiary, and then the trust terminates. We don't like drafting that way anymore because we want to protect those assets for the beneficiary. If those assets get distributed out to that beneficiary at age 35, now the beneficiary receives those assets. They put the assets, the inheritance, in their own bank account. And now it's subject to potential creditors. If that beneficiary has a creditor issue, is being sued, whether for any reason, business, personal, or potential divorce issue. If that beneficiary is going through a divorce, or let's say the beneficiary receives those assets at age 35, and then their spouse files for divorce a year later when they turn 36, now what? Now is that inheritance subject to the divorce? Now that's that spouse. I mean, we get clients, I'm sure you guys see it. They love to complain about their daughter-in-law or their son-in-law, right? So, a lot of times that's one of the big questions they have is, I want to make sure my son-in-law or my daughter-in-law doesn't get access to this. Or maybe their children are already divorced, and they know they want to protect it from that former spouse, and they want to make sure that that's protected. So, the historical way to draft, and we still see some clients come in with that mentality of stage distributions, and where we tell them, no, we like to keep assets in trust. It's protected for the beneficiaries from creditors and from spouses or potential divorcing spouses. And there are ways we can still give the beneficiary some flexibility and control, but try to keep the assets protected to the extent we can.
Josh, before you go on,
Yeah.
I just share an example of my own family.
Yeah.
About 12 years ago, we were doing some generation skipping planning, right? And so we had my kids came to the meeting. My son was single, now married. My daughter was married, now divorced. And the attorney was explaining to the kids that this provision in the trust, if your parents die before a certain age, the trustee has the power to invade principal, assuming this trust assets, to give you a down payment toward a home. Now, we didn't die, fortunately, but
Right.
My son heard that and said, wait a minute, trustee has directed. My son said, I know the trustee, he's a cheap B, he's an executive, he's an attorney, my father's a dear friend. I grew up living in a big house, I'm not moving to a shack. So the attorney changed the drafting to say the following: the trustee has the power to evade principal, assuming this trust assets, to give you a down payment toward a home, similar to that which you grew up living in. My son felt comfortable, he got drafted, and then 10 years later, going across Alligator Alley, my son's doing his own estate planning. His wife then was pregnant, she now has 2 children. And I relayed the story to his attorney, who laughed. My son then said, wait, Dad, that was 10 years ago. I'm on your side of the aisle now, it's 10 years later. So how you drafted and the words you use in a document have an implication short-term and long-term.
Yeah, no, absolutely. And that's a great point. And yeah, typically, the beneficiaries have those concerns and say, wait a second, is how are these assets tied up? What can they be used for? What can the trustee do? And so we like to draft them as flexible as possible, but certain clients have certain provisions that they want, and we can narrow it as to the extent that they want, or we can keep it broad and flexible. And so, yeah, no, that's certainly a good example.
Right. So what I took from both of that is that the trust really has the ability, like you said, to be flexible and really draft it to the way that the grantor wants it to be. But at the same time, we got to think, we almost have to draft those contingencies in there so that it protects what they want to have happen.
Yeah, absolutely. Yeah.
So
Certainly.
kind of on that same topic, Mickey, switching over to you, throughout your career, what type of common mistakes have you seen when it comes to both the ownership and the beneficiary on certain accounts, such as like IRAs and life insurance that pass to direct beneficiary? We don't need to go through a trust.
Okay, so let me give, and that's a good question, Michelle. I'll give a couple of examples. Let's assume a young family has young children, and we see this designation a lot. The spouse is primary, and then children of the insured are contingent beneficiary. Now, just by using the word children of the insured, if the spouse would have predeceased the insured, then children of the insured means any child of that insured. So if it's a guy that's the insured and he would have happened to father another child or is claimed to have done that in the court, that child could maybe share in a benefit. So one example is you just make it simple by saying children will be insured by spouse all equally, and thus it's the children of you and your then spouse. Having said that, if the children are minors, just picture this: you've got 2 young children, like Michelle, you've got a couple of young children. If you and Rob were to pass, the life insurance will be paid to your children, but the insurance company can't pay a minor, so they would pay it to the court, and the court would appoint a custodian to control the monies until the child was of majority by statute, by state law. So every state has a gift to minors provision. So one example would be when there's a contingent beneficiary, especially their minors, use the state gift to minors provision, which allows the insured to select the custodian today and how they want the distribution, like Josh talked about, in what increments in the future. And another example, let's assume you have assets now. I have a great story. got referred to a surgeon, very successful, gave me a shoebox worth of stuff. And said, can you review my stuff? Insurance, pension documents, life insurance trusts, investment accounts. And in our conversation, he's telling me, my ex-wife is an attorney. I'm remarried. But when I want to take my kids from my original children on vacation, I got to go to court every time to fight my ex-wife. So it's obviously he doesn't like his ex-wife, and she doesn't like him. So I get all the documents, and he hired a top New York law firm for the divorce. And what did I learn? That the ex-wife is still the primary beneficiary of his pension plan, which has maybe $3 to $4 million of assets. Now, based upon federal law, if he were to die, the ex-wife is entitled to 50% of the benefit, and the new wife would get 50%. So I shared that kind of pre-discussion with Josh earlier in the week. We were planning the seminar, and Josh, the kind of person he is, either he or his team did the research on federal and state laws, and we both learned something interesting. Florida is one of the states that says if you're divorced, the assumption is that the spouse predeceased you. And then we said, but wait a second, that doesn't govern ERISA guidelines. So when it comes to like pensions versus an IRA, in a qualified plan, ERISA trumps state law. So in the example that I gave, the ex-wife would have gotten half the benefit. If it's an IRA, then state law trumps, because it's not ERISA. The assumption is that the ex-spouse predeceased the insured. So those are a couple of examples of why it's important always to look at beneficiary designations. Divorces can happen, life can change, children can be young, can get older, and it's important, a couple of important points.
Right. And something we've seen a lot, right, is that going back to when families that have young children, or that they've done planning with the estate planning attorney like Josh or someone, and they take the time to do the revocable trust and really think through it, then they never go about changing the beneficiary to the revocable trust on those type of products, and it's listed to the children directly. So they did all that planning and spent the money for the documents, but then it doesn't get to be executed the way they wanted because they just forgot to make an update. There's simple changes.
Let me give you one more example. We had clients in our office up north. Now, he was the client, not his spouse. And so we actually brought a law firm in. They were drafting irrevocable life insurance for us to hold the life insurance. And he names it in the draft. I named my spouse as income beneficiary of this irrevocable trust. After the meeting, the next day, I said to the client, I noticed you named in the document my spouse, not by name. He said, yes, Mickey, I think I may be divorcing my wife. And if I name spouse as the primary and I'm not married, then my kids take over as the beneficiary. So I felt bad for the ex-wife, but she wasn't my client. So that's a little example in an irrevocable trust. The change of one word from spouse to spouse by name has an enormous impact on how benefits are paid out.
Yeah, we call that the floating spouse provision, where whoever the individual is married to at the time is the spouse.
Okay, so we covered beneficiaries there, right? So we talked about some of the common mistakes with beneficiaries, but let's change that now and look at ownership. So Mickey, oftentimes the ownership of life insurance, doing it correctly or incorrectly, can have a massive tax complication. Right. So share a little bit about how that could work.
Well, so depending upon the size of your estate will impact the effect of estate taxes on, including life insurance. So let's assume you're the owner of a life insurance policy and you name whomever you name as beneficiary, spouse, children. At death, the life insurance proceeds are in your estate for calculation for estate tax purposes, both at a federal level and a state level if the state does have a state estate tax. Some states do, some states don't. Under federal law today, the exemption is about $13 million per person, 26 million per couple, indexing slightly for inflation. And that bill sunsets end of 25, so 1/1/26, it goes down to what, about 6 million, 7 million, Josh?
Yeah, it'll get cut in half. So whatever it is with inflation next year.
All right. So for many people, if they have a large estate, moving life insurance out of your estate does a few things. It can take it out of the calculation for estate tax purposes, both federal and state, as well as protect the house from breach of creditors. So an important point is consider, when appropriate, using a life insurance trust that Josh and professionals like Josh can talk about, and making sure the ownership and beneficiary is as you want it to be, both today and tomorrow. Another part is, and Josh talked earlier, life insurance with named beneficiary bypasses probate. By New York law, and the term is different in Florida, but the same consequence. It bypasses that, so it goes directly to the beneficiary. So ownership is a really important factor, and we've seen lots and lots of mistakes, and people get busy, their life changes, and they don't make changes. So let's assume my wife predeceased me, and my children now, one is married, one is divorced. So do you change the beneficiaries now, the contingent beneficiaries, to protect your children from a spouse, to protect your grandchildren should you have some? So it's a moving equation that needs to be looked at with regularity. And go with professionals like Josh and others, I think it's the right place to do that.
So Josh, Mickey spoke, about assets that pass by beneficiary, which are, retirement plans, IRAs, life insurance, but people have other assets that cannot pass by beneficiary. Most commonly, someone's home or a rental property, or even simple as cash. So what type of mistakes have you seen on the ownership level with those types of assets?
Yeah, no, absolutely. It's a great question. It dovetailed what Mickey was talking about, where, as I mentioned before, and just to highlight that point, because I think it's a good one that Mickey made with your will and your trust. Your will and your trust can be great and say everything you want, but if you don't coordinate beneficiary designations, IRA, life insurance, and other assets, and titling, then the will, the trust may not be worth the paper it's written on, right? So we want to make sure that all of the assets, and taking that holistic view, all of the assets are consistent, and the beneficiary designation and the ownership are consistent with what the client wants. And so bank accounts, some investment accounts, you can make those what are called POD or TOD, pay on death or transfer on death. So they act similar to a beneficiary designation. And some clients have that on their accounts. They set up those accounts a long time ago, and they may have put a beneficiary designation on there and they forgot about that, right? So when we go through this process, we need to know what designations are on each asset and each account. And once the will and the revocable trust are set up, going through and retitling what needs to be titled into the revocable trust is extremely important, because if we don't go ahead and retitle that investment account, that stock account that has a pay on death beneficiary designation, it's going to go as that beneficiary designation. It will not go according to will or the trust, just like the insurance and the IRA or 401k. So we want to make sure the asset gets retitled, so then the beneficiary designation gets updated. And when those assets are retitled into the name of the trust, now everything falls in line and goes according to the way that the clients want. Like Mickey said, clients get busy, they come in, they think, all right, I signed my will and my trust, I'm done, right? But that's not until those are signed, then we have to look at those other assets. And we should, of course, plan before that. But once the trust is signed, then we can go ahead and retitle assets to the name of the trust. So those other assets, maybe it's real estate, maybe it's an investment property, maybe it's that investment account, or any other asset that has a title. We'd like to retitle that into the name of the revocable trust, because we want to avoid probate. We want it to stay in trust for beneficiaries. We want to protect it for the next generation and future generations. And so that's something that sometimes just gets lost in the shuffle. Clients just don't do it. They get busy. They don't realize, they kind of forget about it, or we follow up and they say they'll get to it and they never do it. So retitling those assets and making sure that the ownership and the beneficiary designations are consistent with their estate plan is important. And sometimes clients just like to take the easy way out. They think, you know what, I don't want to deal with this trust, or I don't want to deal with the estate plan. What's the simple way? What's the easy way out? We had clients, I was talking to a client last week where she wanted to name her sister, put her sister on her investment account, and her sister is 10 years younger, said, you know, when I pass, my sister knows what to do. She'll distribute the money to my kids. Well, that's not ideal for a number of reasons, right? One, okay, now what if sister predeceases you? So she's off that account, it's still your account. And now you have health issues or you're incapacitated. So now you can't change your estate plan. Now you can't do anything. So now you're stuck. Or what if your sister, you pass away, your sister survives you? Now that's your sister's account. And if she then distributes it to your kids and she knows what you wanted, or she knows what your wishes were, now that's gifts from her, because now that's her money technically. So even if it's a moment in time, she now has to file a tax return for those accounts. It creates tax issues. There may not be a gift tax issue, but she has to report those gifts. She has to file a tax return if she now gives it to that client's beneficiaries. Or what if now her sister has health issues and her sister says, you know what, I need to help pay these medical bills. I'm going to use some of this money, right? Or maybe the sister was happily married and now she's going through a divorce. So many things can arise. There's so many issues. And so clients trying to take the easy way out, saying, oh, I'll put my son on this account. My son and my daughter, they have a great relationship. My son will be on this account, and then he'll give half of it to his sister. You know, unfortunately, we've seen too many instances where money has an effect on how people act, right? And so we don't want to leave that up to chance. And yes, clients may trust their family members or their siblings or their children, but we want to make sure it's done right and not take the easy way out, because unfortunately we've seen all too often where the person that was trusted with that doesn't necessarily do the right thing.
And before Michelle comes back, just a question and a comment. Question would be, you've done the estate plan. I know you very complete. Client puts a ribbon around, I'm done. So comment to that, like for today and for the future. And secondly, about how money affects family. In my wife's family, second cousin, the parents created a house trust where you transfer the asset to a trust at a discount, and at some point in the future, the kids own the house. This actually happened, and the parents did not put a rental agreement into the document. So I think it was 10 years and a day. The kids threw them out of the house.
Threw the parents out.
So the parents had no place to go because the kids said, get out, we own the house now. Now, and a house trust, and maybe comment, many times they put a rental agreement, but
right.
That kind of area, then the comment about when a client completes their estate plan, are they done? Can they walk away from life?
No, so they're not done and they don't walk away for life, right? We then send them a memo. We follow up. Okay, these are the beneficiary designations. These are your assets. As part of the plan, we get or we request a financial statement of all their assets. So we do those follow-ups, and then we periodically reach out, send a letter every couple of years, just touching base, right? Have any family situations changed, financial situations changed, circumstances changed? Do you have another child, another grandchild? There may have been changes in the law. And so estate plans should be revisited probably every 2 years is a safe bet. Probably most clients maybe are closer to 5 years or more. But certainly every 2 years, clients should just take a quick look at it, refresh, call their attorney, say, hey, I just want to make sure I'm not missing anything. There haven't been changes in the law. Is there anything to review? Because oftentimes clients will come back to us, or a client will come to us from another attorney, and they'll have documents from 5 years ago, and they'll say, I don't even know what this says, or I don't remember what I did, right? So we want to make sure clients recall what they did, and if they want to make changes, if any circumstances change, make that tweak. May be a simple tweak, it may not be a big deal. And then to the house trust that Mickey referred to, it's commonly referred to as a QPERT, or a qualified personal residence trust. That's really done for estate tax planning. And yeah, the thought there being that the residence is, whether it's the primary residence or a vacation residence, gets transferred to a trust. The clients get to live there for a certain number of years. once that term, let's say it's 10 years, once that expires, now the trust is owned, now the residence is owned by the trust. It's great to transfer wealth from an estate and gift tax perspective, but then when that period ends, yes, the client then has to rent back their property. And again, it's from a tax perspective, it's a great plan. But if you don't have that prearranged, if you don't have that rental concept discussed beforehand, you could end up in a situation where children say, "Thanks for the vacation home, mom and dad. We're using it all summer." And we don't like putting our clients in that situation.
So Josh, question for you, kind of talking about real estate. Now, I know the Cupert's more of like a complex, for estate planning, but what is some simple planning that should be done for someone's primary residence, right? Should that be in trust? Because that, if my understanding is right, that could be part of probate, and the price of real estate is only increasing, especially for those of us in South Florida, could be a very large asset.
Absolutely. So yeah, no, it's a great question. And real estate a lot of times is one of the biggest, most valuable assets clients have. And that could be somewhat state specific. For example, in Florida, we have this concept of homestead. So there's your homestead for creditor protection purposes. When many clients know, Florida is a sunny place for shady people, and you can have this homestead protection. It's a creditor, debtor-friendly state where a creditor cannot take your home. That's why OJ, when he had all those judgments against him from the Goldman family, he went and moved to Miami from California, bought a nice big house in Florida and said, "Okay, you can't touch my house. I can live in here forever. Doesn't matter how many judgments you have against me." And so in Florida, homestead is a very special asset. Not only does it have the creditor protection benefits, but there are also property tax benefits where your homestead, if it's your homestead, the property appraiser, when you get your tax assessment every year, it's capped. It can't be increased more than 3% per year. So you're capped at an increase of 3% per year with homestead. So Florida homestead is a very special asset. It needs to be planned for accordingly. Typically with spouses, we may say, keep that joint. If spouses, another way to avoid probate where clients want to take the simple way out is they keep assets joint. And in some instances, that's fine, because if one spouse dies, then the surviving spouse automatically owns that asset and not subject to probate on the first death. But then once that first spouse dies, if we have a single individual that owns a home in Florida, yes, you may want to put that in your revocable trust to avoid probate upon death. And so there's some others, other states as well. You certainly want to try to avoid probate in many states, New York, Florida, some of the larger states, like I said, that have courts that are really backed up. And so your primary residence, you want to make sure either it's titled correctly, whether it's joint or not, and just take into account all those other considerations, particularly in Florida homestead, because sometimes trusts can mess that up a little bit. So we just need to be careful, but in a lot of instances, it certainly does make sense to transfer to your revocable trust to avoid probate.
Got it. Okay, so Vicki, we've talked about a couple different mistakes, right? Common mistakes that we've seen people make on their estate planning. So based off your experience, what would you say is the largest mistake that you see most often, or the most common mistake, I should say?
I think Josh talked about it. It's procrastination. I'll get to it. It's not that important. And typically, either people like ourselves, Michelle, you and I, or professionals like Josh and his colleagues, initiate that kind of discussion, or something happens in life. Somebody dies, somebody gets really ill, catastrophe strikes, and hopefully it wasn't too close to you, because that may have eliminated your ability to do certain things that you would have done or could have done. We have lots of clients that come to me, somebody just died, I want to move my insurance into trust. I'm not feeling well right now. And great technique. The problem is the government says, if you want to transfer life insurance to an irrevocable trust, you've got to live for 3 years after the date of transfer. So it's important to do that before death is imminent. But I think procrastination is probably the #1 issue. Or the second biggest one is, I already did it. I did my estate plan 10 years ago, no problem. And I really some stories and examples in the family where the ex-spouse is beneficiary. So I think relooking at documents like Josh talked about every couple of years, and he's then said most clients actually want to do it every 5 years, and they got to be prompted to it. So procrastination is key, I think.
Yeah. Just to
So,
touch on that really briefly, it's a similar example where client didn't revisit their estate plan. Client had a son that was wealthy, a real estate developer, always did well, and client didn't want to trust for their son, said, you know what, when I die, my assets can go to him. He's responsible. He's not going to spend money. He's very thrifty. He's good with money. He's successful. He's in a real estate business. He's doing great. I'm not worried about him. 2007, 2008 comes around, downturn in the market, real estate market is tanking, and now son's business potentially on the verge of bankruptcy, and financially he's not doing as well. And so that client passed away around that time, never got to update their estate plan, and now that their son, who years ago was very successful, now in a struggling business, now receiving those assets that may be now subject to creditors depending on how bad his business is. Now, if the client had a trust from the beginning for his son, or seen the situation, said, you know what, I'm going to update my plan to make sure I create a trust for my son so that they're protected. So if his son's business does go down the drain, or he files for bankruptcy, or his business goes out of business, at least that inheritance is protected and is in trust. And so that's one of the circumstances that, people don't think about.
Let me give you one other quick example. A New York law firm brought me into a family that owned a block on the Bowery. Now, the Bowery today is major real estate. It's not like it was 50 years ago. And the law firm, trust and estate attorney, the law firm said they need to do some estate planning. They probably need life insurance to help pay taxes. So I meet the family, and there were 3 generations involved in this real estate empire. And it was pretty clear to me that they didn't have a lot of liquidity anymore. So there was a famous insurance agent who's now deceased named Ben Feldman. And he wrote a book, and in the book he said, when he said, put me on your payroll. Meaning, if you put me on your payroll as an employee, in theory, I found the money to pay premiums for life insurance. So I used that line when everything else failed. And this old gentleman, had to be in his late 70s, I said, look, you own 18 buildings in the Bowery. Sell part of one. You'll have 17 and a half. And we found the capital to buy life insurance to pay your future taxes. He thought I was stealing his firstborn, so it didn't work. He actually did money planning, but the point of that is planning is important to do, but not everybody wants to do it.
All right.
right. So I'll share one really simple common mistake that we see, that is, we talked about having joint assets, but there's certain assets that can't be joint. An IRA, for example, a retirement plan, that cannot be a joint asset. I've seen too many times that people haven't gotten their power of attorneys, and something has happened to the owner of that IRA. If you try to call Fidelity, Schwab, UBS to get information on that IRA of your spouse, they're not going to tell you anything because you don't have that power of attorney and you don't own that account. And as you can imagine, in today's world where everyone is a hacker, right, and trying to do a scheme on something, that the financial institutions have even upped their security level. So without the proper legal documents, you're really not going to go anywhere, but you just kind of go in circles and lead to a lot of frustration.
Hey, Michelle,
Yep.
Some posted a question about a half hour ago. I think they've
Yeah, I was Brett was going to go right into this right now, actually. Yes. So when we're talking about the trust, so we have one more point, but a question that got brought up about the trust, it said, why would the revocable trust change to an irrevocable trust upon death?
Yeah, so great question. So back to basics, the will and the revocable trust. I said the revocable trust is revocable as to the person that created it. So as to the grantor. So I create my will and my revocable trust, and I name my beneficiaries in my estate plan. I could always change that during my life. Upon my death, now my wishes are set in stone. So now now the revocable trust does become irrevocable upon the death of the person that created it. And so that's, that those wishes, just like a will, after the person passes away, if they did not have a revocable trust, if you just have a will, the individual passes away, now their will cannot be changed. That's their will. So it's the same concept with a revocable trust.
It's run its time. So we've talked a couple times up to this about the federal estate tax change that is proposed to happen in 2025. So Josh, what are some strategies that are timely, right? Because 2025 is going to be here before we know it, that someone could utilize to take advantage of the positive amounts today versus what they're going to go to.
Right. Yeah, no, great question. That's sort of the hot topic in the estate planning world right now, in terms of, okay, we know we have until the end of 2025 before the estate tax exemption, as of today, is scheduled to revert back to levels from prior to this tax act going into effect. So if it goes down to $6 to $7 million, what can you do? For those clients that have the ability to make gifts and to use their exemption, now is the time to do it. It really is a use it or lose it proposition, because this estate tax, this 13.6 million estate tax exemption, applies to gifts as well. It's a combined gift and estate tax exemption, meaning that an ultra high net worth individual can gift $13.6 million now, or assets valued at 13.6 million, to anyone they want, to a trust for their children, grandchildren, etc. And so if you use that 13 million now upon death, you don't have a state tax exemption yet, but you've transferred 13 million tax-free today, and that just gets to continue to grow during that person's lifetime. So client is 60 years old, transfers 13.6 million to a trust today, that client dies 20 years later. Well, that trust, that 13.6 million might be 50 million at the time of death. None of those assets are subject to estate tax, pass free to those beneficiaries. So the ability to this is the highest exemption we've ever had in this country, the ability to transfer that much wealth now, if the client does not act, and then in a year and a half, it goes back to 6 or 7 million, well, you've missed that opportunity to gift that extra exemption above the level that it goes back to. So gifting now is a hot topic. Of course, gifting requires giving up control. It requires the use of irrevocable trusts. And so one way to alleviate some client concerns with that is the use of what's called a SLAT, spousal lifetime access trust. So one spouse can create a trust for the other spouse, where if the grantor needs or still wants that, doesn't want to lose that control, well, their spouse is a beneficiary. So then their spouse could potentially take out distributions and they could use it for their lives. Ideally, the point is to transfer it and not utilize it. That would be anti-estate planning, to transfer the exemption and then use it. But it gives clients a safety net, a backdoor to say, just in case they need access to it, well, their spouse has access to it. So there are some flexible vehicles and opportunities that clients could take advantage of to take advantage of the estate tax exemption before the exemption is potentially rolled back next year. And there's still some all the typical planning opportunities that have been around for a while, QPERTs, which we mentioned before, charitable remainder trust. Some of these vehicles and planning opportunities are better in higher interest rate environments. So now that interest rates have ticked up over the past couple of years, QPERTs are now popular again. Charitable remainder trusts are popular again. When interest rates were lower, charitable lead trusts were popular. GRATs were popular. GRATs are still a good technique, a good vehicle, a good tool to use for estate tax transfer. GRATs have been on the chopping block legislatively for a long time. Even in the recent Biden revenue or budget proposals for next year, there are proposals to really roll back the use of GRATs and require a minimum 10-year GRAT. Short-term GRATs can be very powerful planning tools, 2, 3, 4-year GRATs. That's how the Walton family, that's why 5 Walton kids all have over $20 billion. because they created what was called the Walton Grat back in the day, and used grats to really transfer wealth to the next generation, and they've been able to really shelter that from estate taxes for a long time. And so grats are still viable options, even though interest rates have ticked up, but they've been on the chopping block for a while. So the government, they know how effective and useful grats can be, which is why they've tried to curtail them to a certain extent.
Right. So I think something for people to keep in mind, Josh, you said for ultra high net worth individuals, right? Because right now it's for estates over 26 million, but people that don't have an estate to that level today possibly could still be thinking about this, because now if that get cut in half to 13 million and you're sitting on an estate today worth 6 or 7 that's accumulating because you're not really drawing off of those assets and it's growing by more than that, you could now potentially down the road in 15, 20 years have an estate tax problem on the federal level.
Absolutely.
So those are all things we look at as a holistic plan of not just where you are today, but who could you be in the future?
Absolutely.
Michelle, with 9 minutes left to 8 o'clock, maybe we can get to a few questions.
Yep, that was what I was going to lead to next. So that was our last question, kind of on the timely strategy. So if anyone has any questions from any topic that we covered tonight or anything that we didn't cover that you would like just some clarification on, feel free to put that into the Q&A right now, and then I will read that.
You actually have a Q&A, right? It's been running for a while.
We covered that one.
Okay, good.
Yes.
Mhm.
So I did get one that was, I think, Josh, you could handle this. When it comes to that core basic package, right? And you mentioned like the living wills, the power of attorney, all of that. Does that need, like, let's say you have a couple, right? Do they each need one, or is it one document that would cover both of them?
So no, they would each need their own set of documents. They would each need their own will, power of attorney, healthcare surrogate designation, revocable trust. We typically draft where each client, because it can't have a joint will. There's no concept of that in Florida and in most states. So you each need your own will, which then makes sense to each have your own revocable trust. Joint revocable trusts are, although clients think they'll be simpler on the front end with one trust, it complicates things upon death on the back end. And so typically each client would have their own will, their own revocable trust, their own power of attorney, healthcare surrogate designation, and living will. And oftentimes spouses' documents are mirrors of each other, which more or less say the same thing. If it's spouses, one common marriage, children from that one marriage, oftentimes the wills are somewhat mirrors. But yeah, each individual would need their own set of documents.
Right. Another question that came in was, how much is probate? What's the average percent?
Right. So in Florida, there is what clients ask about percentage and how fees are paid. And so in Florida, there's a statute which sets out what the executor or the personal representative in Florida, their statutory fee in terms of what they get paid for serving in that role. So there's a sliding scale schedule depending on the level of assets. It's a percentage of the level of assets, and as assets get higher, the percentage gets a little bit lower. But in terms of probate, it's more the fact that there are additional hoops to jump through. So you may be paying more in legal fees as well to go through that process, and it slows everything down. Beneficiaries may need liquidity. They may need access to money. And while it's tied up in probate, so for example, in Florida, once a probate is open, there's a creditor's claims period. So the personal representative has to publish what's called a notice to creditors. And creditors then have 3 months to make a claim against the estate. And oftentimes, there aren't many distributions that can be made from the trust until the creditor's claims period expires, because the court wants to know that there isn't any creditor out there that's owed money, and they want to make sure money is there to pay the creditor of the individual that passed away. So you're subject to these restrictions imposed by the court. And so yes, the cost is a little bit more in that sense, but it's also some of the restrictions and the timeliness, everything. It just slows the process down.
It's a headache. It's basically what it sounds like.
Yeah.
Yeah.
Exactly.
Well, that was all of the questions in the Q&A. So no one else has any further questions. I'll give it a couple more seconds for anything to come in, but I'll say we will wrap that up for this evening. So thank you, Mickey. Thank you, Josh. Thank you, everyone that was able to attend live. It was recorded, so we'll send this out to everyone so they can view at their own time as well. So no other questions came in, so I wish everyone a good evening and have a great night.
Thank you.
Thank you very much.
Thanks for having me.
You're welcome. Thanks.